A federal court just admitted millions of Americans legally own AR-15s, then said states can ban them anyway. One judge decided your constitutional rights don't matter if he thinks your firearm is too dangerous. The Supreme Court decides this case January 23rd, just 2 weeks away, and the outcome determines whether you keep your AR-15 or face felony charges for owning America's most popular rifle. Today I'm breaking down 7 facts about this Supreme Court case that could strip your gun rights overnight. By the end, you'll know exactly what's at stake and when the decision drops. Here's why this is urgent. If the court refuses this case, states get the green light to ban any gun they want. AR-15s today, handguns tomorrow. This isn't speculation. 7 states already have these bans affecting 70 million Americans. More states are waiting to see what happens. January 23rd determines everything. Connecticut passed a law making AR-15 ownership a crime. Not restrictions, complete ban. Possession equals prosecution. They also banned any magazine over 10 rounds. Your factory Glock 19 magazine, illegal. Your standard AR magazine, felony possession. The law classifies AR-15s as assault weapons and criminalizes sale, transfer, and possession. You can't buy one, you can't inherit one, you can't keep the one you already own. 7 states have copycat bans: California, New York, Massachusetts, New Jersey, Maryland, Hawaii, and Illinois. Here's the devastating part. AR-15s are the most popular centerfire rifle in America. Between 15 and 24 million in circulation, more than Ford F-150 trucks. Standard magazines, hundreds of millions exist. These aren't rare military weapons. They're in your neighbor's safe right now. The case is NAGR versus Lamont, National Association for Gun Rights, challenging Connecticut's governor. They argue these bans violate the Second Amendment because AR-15s are clearly bearable arms, widely owned, and used for lawful purposes like self-defense and sport shooting. If the Supreme Court lets this ban stand, every state with similar laws gets the foundation to expand them, and states without bans will rush to pass them knowing courts will uphold them. This is where it gets insane. The Federal District Court and the Second Circuit Court of Appeals both admitted AR-15s are in common use by millions of law-abiding Americans. They didn't dispute it. They agreed. Then they upheld the ban anyway. The Supreme Court established the test in Heller. Weapons in common use for lawful purposes are protected. Period. The court repeated this in Bruen. Common use equals constitutional protection. That should have ended the case right there. Instead, the Second Circuit created a new rule the Supreme Court never authorized. They said even if a firearm is in common use, judges can still ban it if they personally decide it's unusually dangerous. One judge's opinion now overrides millions of Americans' constitutional rights. This collapses the entire Second Amendment framework. Common use was the bright line. If millions own it lawfully, it's protected. The Second Circuit just erased that line and gave judges unlimited power to ban whatever they want based on personal opinion about danger. The Second Circuit also did exactly what Bruen forbid: interest balancing. They weighed AR-15 danger against gun rights and decided danger wins. The Supreme Court explicitly rejected this approach in Bruen. Justice Thomas wrote that courts must look at historical tradition, not balance government interests. The Second Circuit ignored him completely. This affects every gun owner because it sets precedent. Your 1911? Too powerful. Your shotgun? Too dangerous. Your hunting rifle? Sniper weapon. Once courts can ban commonly owned arms they deem dangerous, nothing is safe. The Supreme Court petition asks one straightforward question: does the Second Amendment protect firearms owned by millions of Americans, even when courts admit they're in common use? This should be obvious after Heller and Bruen. But here we are with circuit courts saying common use doesn't matter if a judge personally dislikes the gun. If the Supreme Court says states can ban commonly owned firearms, the Second Amendment protects nothing except maybe muskets, and even those could be challenged next. Think about what happens next. States will immediately target handguns. Over 100 million Americans own handguns, but they're used in more crimes than rifles. States will call them unusually dangerous and ban them using this exact same reasoning. Your concealed carry gun? Gone. The plaintiffs are asking the Supreme Court to simply enforce their own rules from Heller and Bruen. This isn't requesting new rights. This is demanding lower courts follow Supreme Court precedent instead of openly defying it. When the Supreme Court denied Maryland's assault weapon ban case in 2023, Justice Kavanaugh wrote something important. He said the court was denying that specific case because lower courts hadn't applied Bruen correctly yet, but the Supreme Court would likely need to address assault weapon bans in a future case. Kavanaugh acknowledged AR-15s are commonly owned for lawful purposes, including self-defense. He recognized the constitutional problem with state bans. His message: lower courts need to follow Bruen, and if they don't, the Supreme Court will step in. That was the promise. Now the Second Circuit has openly defied Bruen. They admitted common use and banned AR-15s anyway. This is exactly when Kavanaugh said intervention would be necessary. The plaintiffs directly cite Kavanaugh's statement in their petition. They're saying, "You promised to address this. Lower courts are defying you. Time to act." Every month the court delays. More Americans face prosecution for owning commonly used firearms. Every term without action, more circuits follow the Second Circuit's defiance. If the Supreme Court won't enforce their own rulings, those rulings become meaningless suggestions. While the Connecticut case goes to conference January 23rd, two other massive cases are being decided this week. First, Duncan versus Bonta from California. This challenges California's ban on magazines over 10 rounds. This case has been bouncing through courts for years. The Supreme Court is deciding right now whether to hear it. Second, Illinois' assault weapons ban passed in 2023. Multiple challenges are pending, and the Supreme Court is considering whether to review the Seventh Circuit's decision upholding it. Here's why timing is critical. If the court grants either case Friday, they might hold the Connecticut case or consolidate the issues. That's standard procedure. They prefer final merits cases over preliminary injunction cases. But here's the nightmare scenario. If the Supreme Court denies both cases Friday, the Connecticut case is dead. The court's refusal signals they're not ready to address these bans, meaning Connecticut gets denied too. We have a 2-week window. By January 23rd, we'll know if the Supreme Court will intervene or if states have unlimited power to ban commonly owned firearms. If all 3 cases get denied, 7 states keep their bans, and a dozen more states will pass copycat laws immediately. Within 2 years, half the country could criminalize AR-15 ownership with zero constitutional remedy. Watch for Friday's decision. Then watch January 23rd. These dates determine whether your Second Amendment right exists nationwide or only in states that choose to respect it. The Supreme Court in Heller said the Second Amendment doesn't protect weapons that are both dangerous and unusual. 2 requirements. Both must be met. AR-15s fail the unusual test completely. With 15 to 24 million in civilian hands, they're the opposite of unusual. They're the most popular centerfire rifle in America. Standard magazines? Hundreds of millions in circulation. These are default configurations, not exotic weapons. The Second Circuit tried to rewrite this as unusually dangerous instead of dangerous and unusual. That's not what Heller said. The court changed the test to ban commonly owned firearms. Every firearm is dangerous. That's the entire point. The question is whether it's unusual, and millions of Americans owning it for lawful purposes answers that question definitively: no. If courts can ban firearms based on danger alone, every effective gun becomes bannable. Semi-auto pistols? Dangerous. Shotguns? Dangerous. Bolt-action rifles? Dangerous. The only safe firearms would be firearms that don't work, which defeats the Second Amendment's purpose. The historical standard shows unusual weapons, crew-served artillery, military ordnance, not typically owned by civilians, could be regulated. But commonly owned civilian weapons for self-defense were never subject to categorical bans. The real issue isn't just AR-15s. It's whether lower courts will follow Supreme Court orders or ignore them. The Second Circuit didn't misunderstand Bruen. They understood it perfectly and ruled differently anyway. That's not a mistake. That's defiance. After Bruen in 2022, the Supreme Court sent dozens of cases back to lower courts with instructions to reconsider using the new framework. Many courts reheard the cases and reached the exact same anti-gun conclusions with slightly different reasoning. They found ways to uphold bans while technically citing historical analogs that don't actually match modern regulations. The Ninth Circuit, Fourth Circuit, and Seventh Circuit have all done the same thing. They engage in what critics call history by analogy, finding some vaguely similar 1789 regulation and claiming it justifies modern bans on commonly owned firearms. The mental gymnastics are Olympic level. When lower courts openly defy Supreme Court precedent, constitutional protections mean nothing. Every right becomes subject to nullification by judges imposing policy preferences over constitutional text. For you as a gun owner, this creates impossible uncertainty. You own firearms that are clearly legal under the Constitution as interpreted by by the Supreme Court, yet you face criminal prosecution under state laws that lower courts uphold in defiance of that same Supreme Court. The Supreme Court needs to grant this case, issue a decisive ruling, and actually enforce compliance. Without enforcement, lower courts will keep finding creative ways to uphold gun control regardless of what the Supreme Court says. January 23rd is potentially the last opportunity this term to address this defiance. If they pass on all 3 cases, the message to lower courts is clear: ignore Bruen without consequences. Let's recap the 7 facts about the Supreme Court AR-15 case deciding your gun rights. 1. Connecticut banned AR-15s owned by millions. 7 states have copycat laws. 2. Courts admitted common use. Banned them anyway. Direct Heller violation. 3. The case asks if the Second Amendment actually protects commonly owned firearms. 4. Justice Kavanaugh promised intervention. This case demands he deliver. 5. 2 cases decide this Friday. Outcomes impact the Connecticut case directly. 6. The test is dangerous and unusual. AR-15s owned by millions aren't unusual. 7. Lower courts are openly defying Supreme Court orders. Constitutional crisis. Any one of these facts shows why January 23rd determines whether you keep your constitutional rights or lose them to judicial discretion. If the court refuses to hear this, states can ban any gun they label dangerous. Subscribe to Guns Law Guide so you never miss Supreme Court decisions affecting your rights. I break down every major Second Amendment case so you know exactly where you stand legally. Next video, 5 concealed carry mistakes that get lawful gun owners arrested at traffic stops, even with valid permits.